All right, everybody have a seat. Jurors, everybody's okay? Everybody's got their paperwork back in place? And remember now, Mr. Lubin gets to go for 2 hours. And Mr. Lubin, if you're ready, sir.
I am. May it please the court. There are no words to describe what a terrible tragedy this is. You know that the Jones family will never, ever get over what happened that early morning. A life lost forever, simply awful. But what happened at 3:15 in the morning was not a crime. What happened on the off-ramp was not a crime. As terrible as it might sound, it was not illegal for Officer Raja to do what he did. He didn't leave home that night thinking, who can I kill? How can I commit murder? Who can I hurt tonight? He left home that night to go to work on the midnight shift with the thought in his mind of doing good as a police officer, to serve and to protect. He didn't leave home that night trying to hurt anybody or to be involved in a horrible, horrible turn of events that began when Corey Jones pulled a gun and aimed it at Officer Raja's head. Let's be very clear about it, emotion aside. Corey Jones took out a gun and aimed it at Officer Raja's head, and everything changed. You couldn't take that back. There's nothing that could be done after that. That was an aggravated assault. That was the use of deadly force. You can't negotiate with a gun pointed at your head. Now, I'm going to say something right up front. I'm going to get it out of the way, and I'm going to say it. This case, as the judge has told you, has to be decided on the facts and not on emotions. It's very emotional. It's terribly emotional. But it's not about emotions, it's about evidence. And it's not about race either. And I have to say it right up front. The first subject matter in the prosecutor's voir dire was about racial killings. 65 seconds into Mr. Fernandez's opening statement, he talked about how a man was killed that night, undeniably a black man. That's not what this case is about. There was a human being killed that night, and the question is, was it a crime or was it a horrible accident and a horrible tragedy? There's no evidence that this was a racial killing. I have to say it, so I'm going to say it, and I won't mention it anymore. There were numerous auto burglaries going on. Let me put this thing down. Not staying. There were numerous auto burglaries going on in the town of Palm Beach Gardens. They wanted to do something about it, and they set up a plainclothes detail in order to mingle in the neighborhoods and to try to find out what it was, who was doing it, who was causing it, and what the situation was. And it's true, in a plainclothes detail, as opposed to an undercover detail, you're not supposed to confront a suspect. You're not supposed to go over to somebody not in uniform and confront them. You're supposed to, if you need to approach somebody, put on a uniform, put on a vest, put on some form of identification. If you can. We're going to talk about Sergeant Garcia in a minute. Although the idea was for him to blend in and to not approach anyone, there are some times where you have no choice. So Officer Raja was in a white van. He had the riot gear in the back of the white van. It was a police department issued van. There was going to be trouble, they thought, at the Lux, which is the Marriott Hotel nightclub, which is just east of I-95 on the south side of the road. And that's what he was on his way to approach. And remember, he wasn't in uniform. He was in his plain clothes, but he was on his way there to approach. You'll remember Officer Garcia. Officer Garcia is the one who kind of was his supervisor on the plainclothes unit. And he said, you're not supposed to approach somebody without a proper identification. But he also said, Raja had to get out of the van that night. He had to get out of the van. As soon as there was a person standing there outside of the van, it's too dangerous to be in the van. He had no time, as he pulled into the off-ramp on I-95, he had no time to put his uniform on. He had no time nor an ability inside the car to put a 25-pound vest over his head. And the thing about it is, when you put the 25-pound vest on over your head, you're also blinded for a period of time. It's terribly sad, but the fact of the matter is, he was right in getting out of the van. Sergeant Garcia said it. He had no choice, and he could not identify himself with that vest. So let's talk about exactly what happened. He's driving east on PGA Boulevard, and he sees what appears to be an unoccupied vehicle on the side of the road. Now think about it. He's on an auto burglary detail. There's a big parking lot right next to that with cars in it, a DoubleTree Hotel parking lot. So he's going to check it out. He's going to see what's going on with the van. Maybe it's just a broken down motorist. Maybe it's somebody having a heart attack in the car. Who knows what it is? But he's going to check it out and see. He made a determination that the van was unoccupied. Well, why did he do that? There were no flashers on. The hood wasn't up. It was dark inside the car, and the driver's seat was reclined all the way back. What else do we know about what was going on in the van? There was a loaded handgun in the car out of the box. How do we know it was out of the box? Well, first of all, there would have been no time for Mr. Jones to get it out of the box in the short amount of time that he had when the light shone on him. But second of all, you're listening to the AT&T tape. He's not rumbling through his belongings and getting something out of the glove box and opening a box. You don't hear any of that. So Mr. Jones had a handgun loaded on the front seat of his car or possibly on the center console when Officer Raja rolled up in his car. Proper procedure would be to talk to a sergeant and get permission to do what he did. That's exactly what Officer Raja did. He called his sergeant. It was Sergeant Anderson, as we've heard, and he said, I'm going to go check out this van, this blacked out SUV on the side of the road, and he got a 10-4. We all know what 10-4 means. That means okay. So he received permission to do that. Now, it's true. He could have gotten on I-95 North, driven all the way up to Donald Ross Road, gotten off the exit, gotten back on I-95, driven all the way down. But it was 3:15 in the morning. There was absolutely no traffic on the off-ramp. what he thought he would do is pull in front of the car, put his flashers on. He said that. Said that in the walkthrough, which was sworn to, by the way. He thought that he could do that in an instant, and it would be easy to get back on the road and easy to get to the Lux Hotel when he was done. Well, he certainly made the wrong assumption and certainly the car was not unoccupied. It was occupied, there's no question about it. So, what happens? Let's talk about this, exactly what happens. As the headlights shine onto the SUV, as the SUV headlights shine onto his car, as the van headlights shine onto the SUV, I'm sorry, immediately the door flies open. He doesn't even have time to turn in front, and we know that that's what he was doing. His wheels were turned to the left. He was going to pull in front of the SUV, and Mr. Jones jumps out of his car. Now, the front door to the SUV is open, and now we have the front door to the van being open, and there's a period where the cell phone is not picking up what is being said. That period right after he gets out of the car, but he hasn't yet rounded the door and rounded the front of the car in order to ask what was going on with Mr. Jones. He didn't have his vest on. Immediately, he sensed that something was not right. He said that he sensed it, and what you can tell from the AT&T call is, he said something. He says, "Police, you good?" or whatever the words exactly were. But immediately he could sense that something was wrong. This is just an instinct, but he knew something was wrong. Something about the way he was fiddling, something like that. So here's what I want to do. I want to start with him getting the 10-4 from his sergeant, just so that we can confirm that happened, and then I'm going to tell you what happened. So can we play that?
258. Just 214.95 off-ramp to PGA. There is a great SUV parked on the off-ramp on the side. I'm just going to go check it out. Harold.
Okay. So he's not worked up. You can tell he's not in a fighting mood. You can tell he's not looking for trouble. He's just going to check out the SUV, and he gets a 10-4 from Sergeant Anderson. Now, the AT&T roadside call picked up some of what happened, but not all of what happened, as we know. It picked up some of what happened, but not all of what happened, because we know that it didn't pick up the initial statements that Officer Raja made. But we're absolutely positive that he made a statement, and we're sort of positive that Mr. Jones heard something, but he didn't hear what it was. There's a transcript in evidence, and the transcript in evidence says unintelligible voice. So the parties agree that something was said. I think Ms. Ellis said in her closing argument that something was said. And we called, just to confirm that, we called Frank Piazza, who is a sound expert. And what did he say? He said that what was said was a human voice. By process of elimination, he was 100% sure it was Officer Raja. It was not Corey Jones's voice, and it was not the AT&T operator's voice. Now, I just want to say that an issue was made over whether it was 50% sure or 100% sure. When he didn't have confirmation that Officer Raja was the only one there, he was 50% sure. But when he had confirmation that Officer Raja was in fact the only one there, it was 100%. That's what he said. That's the facts. There was no one else there. And no, it wasn't somebody yelling out of a car on their way down the ramp. And no, it wasn't somebody from the balcony in the Doubletree Hotel. It wasn't any of those things. That was the cross-examination of Frank Piazza. No, it was Officer Raja, and he was saying something as he got out of the car to Corey Jones. There's nothing to indicate that when he got out of the car, he was looking for trouble. This is not a guy that looks for trouble. There's no evidence that there is.
Sustained. Just rephrase.
He wasn't looking for trouble when he got out of the van and was just trying to check out on what was going on with either the unoccupied van, the unoccupied SUV, or what was going on. So what was said? What was said is that he said, huh. Corey Jones said, huh, in response to what was said. And then you hear, I'm good. Yes, I'm good. And you immediately can tell that Officer Raja felt that there was something going on. Because remember, he's standing on the other side of the door. And the other side of the door, you can't see the person's hands. But something was in his hands. Something was bothering him, and you know what? He was absolutely right. His instincts were absolutely right. There was a loaded gun in his hand. You can't tell whether the safety's on, whether the safety's off, whether it's loaded, but there was a gun in Corey Jones's hand. He got out of the car with a gun. And when he pointed that gun at Officer Raja, everything changed. When he pointed that gun at Officer Raja, it was the use of deadly force, it was a threat of deadly force, and everything changed, as sad as that may be. Now, notwithstanding the fact that he pointed a gun at Officer Raja, and in his rights, Officer Raja could have fired right away. He said, drop. First he said, show me your hands, and then he said, drop. He didn't even have to say drop. He could have just fired because the gun was pointed at him. And we're going to talk about how we know for sure, 100% positive, that the gun was pointed at him. But he could have just shot, but he said drop. And Corey Jones didn't drop. There was a gun pointed at Officer Raja's head, and Corey Jones didn't drop it. And what choice in this terrible tragedy does Officer Raja have but to fire the gun? In self-defense. Not in an aggressive situation, but in self-defense, to protect himself. Now, I want to talk about what we know happened here. You'll recall that this is a diagram that's in evidence. Can you all see it? Yeah. This is a diagram that's in evidence. There's a lot of photographs in evidence, but this diagram really pretty much encompasses everything, and it lays it all out. So what you see here is the van, and by the way, in that animation it was yellow or orange or something, but we've got a white van and we've got the SUV. And you can see that the white van was fixing to pull right in front. Corey Jones began to back up. We know that because he moved away from the door to his car, and obviously you couldn't fire at him with the door there. I mean, you might have a little target, but they came around the car. So 1, 2, and 3 show the shell casings that were fired or ejected from the gun from the first 3 shots. The shell casings that were ejected from the gun in the first 3 shots. Now, it's not an exact science, but everybody seems to agree that the shell casings go to the right and slightly to the back. To the right and slightly to the back. So if I'm holding a gun like this, the shell casings are going to go there and they're going to go there. So you can generally position yourself according to the shell casings. So, somewhere around here, right? Somewhere in this area, around here, the gun was fired. Now, the animation the state has shows a circle on the wrong side of the door moving away, but that's where it was fired. That's where they were fired from, but obviously that's not accurate. So, and it's not an evidence, and it was not subject to cross-examination. It's a demonstrative aid. This chart, for example, is a demonstrative aid, but it's in evidence. It was subject to cross-examination. Somebody could challenge it if they wanted to. But there is a difference between what one side might create and make up to try to highlight an argument and something that's in evidence and has been subject to rigorous cross-examination and a ruling by the judge as to whether it's admissible. Okay, so, all right, so what do we think happened? Well, we know that there was a second round of shots fired, and obviously the gun would have been somewhere over here, right? Because to the right and back, somewhere. It's not clear whether it's here, it's not clear whether it's here, but somewhere the second 3 shots were fired, and obviously Mr. Jones was moving. Whether he was hit in the first round of shots is unknown. Maybe he was. Maybe he received a fatal, terrible wound in the first round of shots. Because what we know is, to receive the terrible, fatal wound, to receive that injury to his heart, he had to have his hand up, I would suggest, as if he were about to fire a gun, but up in some way, exposing the right side of the chest. Everyone said that. Even Dr. Juice said it. That's what had to happen. He had to be doing that. He had to somehow be doing it. But he did that twice. We know that he did it twice because I'll tell you how we know that he did it twice. Officer Raja gave a sworn statement to the police. And here's what he said. He said that Corey Jones moved along, and then he ran the other way and ran around the guardrail and onto the grass, and he ran in this direction. Now, you talk about distortion and memory and so forth. Officer Raja thought that maybe this is where Mr. Jones had fallen. But we know that's not where he fell. We know he fell right by the side, because you'll recall his testimony. He turned, he aimed the gun at me. I fired deliberately. I said to myself, aim, aim, aim. And I fired 3 shots. And he fell down, and I saw something silver fall. He fell down, and I saw something silver fall. And where did they find the gun, which has been described as a silver gun? Right at the base of the sign. He fell down, I saw something silver fall, then he got up and ran into the darkness. And by the way, we're talking darkness. When the police got there, even with the car lights on and flashlights, they couldn't see anything out in here. You remember the testimony about the thing called the stick. It's the ballistic shield, and 3 officers get behind it. Well, they couldn't even find Mr. Jones until they were almost right on him with the stick in the darkness. That's how dark it was here, with car lights and everything else that was going on at the time. So why is that important? According to Dr. Juice, Corey Jones died where he was shot. He instantly fell down and died where he was shot. So in order for the prosecution's theory to be accurate, in order for their story to work, Corey Jones had to have been shot here. The shell casings are here. Corey Jones had to have been shot here because that's where he fell and that's where he died. He couldn't have run. What did Dr. Juice say? 1, 2, 3 yards if he were already moving. It's impossible under her theory, under the testimony of the expert that's called by the state, the forensic expert that they're basing their entire case on, has said that this is where Corey Jones was shot. It's impossible. A, it's pitch black. And B, something silver fell when I shot him 2, 3, 4, and 5. Something silver fell, and they found the gun right at the base of this sign. I don't know if counsel was suggesting to you that possibly the gun was planted. I don't know. There's no fingerprints on it. The only DNA is of a family member of Corey Jones. I don't know what they're suggesting about the gun in the long grass, but the testimony of Sergeant Sprague was that Corey Jones said something about dropping it in the grass, and he pointed to an area around here, and that's where they found it. Now, the Sheriff's Department and the FBI, they didn't bother to search for blood, but I would suggest to you that if they had gone out with a white light at night, like they should have done, they probably would have picked up some traces of blood right on this pad, and we wouldn't be here. But they didn't do it. And what blood would have likely been on that? Well, maybe not tremendous amounts of blood, maybe droplets. But remember, he skinned his arm, and the only logical place that he could have skimmed his arm would have been on some hard surface, and that's a asphalt base of the sign there. Otherwise, it's all grass. But he skinned his arm, and we know that for sure he was shot by now, because all 6 shots had been fired. If he was shot, it's likely that there might have been some evidence, some blood evidence connected to that. Now, I'm going to talk a little later about whether it was a lie to say, I thought it was here. But I do recall, and I'm sure you'll recall too when you watch it again if you haven't already, that Sergeant Karpinski, who was doing the walkthrough interview, or one of the officers doing the walkthrough interview, told him to estimate, because he was saying, I don't remember. I don't know where exactly I was, but just estimate, just throw some cones here. And there was even some talk about him not going into the grass because they didn't want him to get wet. You'll hear that on it if you listen to it. So, all 6 shots have been fired by here. What evidence is there that Corey Jones was a fleeing man in fear for his life? I don't think there's any evidence. I mean, there is no evidence. It's speculation, it's hypothesis, it's assumptions maybe that work well for the state's case, but there's no evidence that he was running until, I mean, he was moving in this direction, but running until he ran off into the darkness. And by the way, I'll probably say it again later, but I just wanted to say, this testimony, this evidence does not show that Officer Raja knew that Corey Jones was dead. To the contrary, first of all, remember the young lady, Kelly, who was on the balcony of the hotel? She came outside right after this happened, and what did she see? She saw, and no one was there yet, there were no police officers there to put on a show for her. She saw Officer Raja with the gun in his hand and the cell phone backing up towards his van. That's what she saw. And you'll recall that the 911 operator said, well, Raj, go get your phone. Where is your phone? Well, it's in the, go get your radio. Where is your radio? Well, it's in the van. So she saw that. That confirmed it. That confirmed. And also on the 911 call, he said, I don't know where he is. I've lost sight of him. I've lost him. I'm not behind anything. I mean, he truly believed that he was still in danger. He didn't know what injuries the man had received, but he did say he thought he hit him 3 or 4 times. And he said he used the term one man down, I got one down. But there's no evidence to suggest that meant down and laying there, because obviously he's yelling commands at him, as you should do. Remember, the sergeant said in testimony, Sergeant Garcia, I think it was Sergeant Garcia, it was one of them, that you can't assume that there's only one gun. And he had seen something silver fall, but you can't assume there's only one gun. He was scared that there was still an active shooter or an active person with a gun out there. But anyway, that's where the body is. This is where the shots are. This whole theory about attempted murder, when you apply it to the facts in the case, it doesn't work. When you apply it to the facts in the case, there's obviously no attempted murder. What there is Corey Jones aiming a gun, which we now know is loaded. He didn't know it was loaded or half loaded or safety on. He just knew that a gun, a silver handgun, was pointed at his head, and that he turned as if to fire here, and he turned as if to fire here, and he fired all 6 shots before Corey Jones ever reached the sign, let alone out there. Now, I'm not sure if there was some implication during Dr. Just's testimony and the examination by Miss Ellis, but there is no evidence that Corey Jones was running and got shot in the arm as he was running. No, the shots were all fired while Corey Jones still had the gun. And it was all over way before he got out here. It was all over by the time he was at the sign and dropped the gun. The shots were not fired before the gun was dropped. We know that. The shots were fired after he turned for the second time, aimed his gun at Nouman Raja, fired, he fell down, something silver fell, and he ran off into the distance. Get some water. So maybe this would be a good time to talk about what Michael LaForte actually did at the scene. And we'll be wanting to use some of his pictures. I'm not. Is this on? Yeah. Okay. So what did Michael LaForte do? If you can see this, there was a fresh bullet strike in this tree the palm tree. It was a fresh bullet site. It had raised edges, and it had fresh sap running down, and that was in the crime scene photographs. So what he did is he just merely lined up things, okay? And what I would say to you is, that is consistent. That first tree strike is totally consistent with the first 3 shots that were fired. One of them hit that tree. It didn't go off into here. Shots weren't fired in this direction. One of them hit that tree. I mean, it's the only logical explanation. But the police, the FBI, everyone that came to the scene originally missed that there was also a bullet hole in this tree, if you'll recall. So the thing he did was, and there's 2 pictures that, and I'm going to use them both just so you can see. I don't know if you can see the pink line there, but that shows, what that shows is the beginning of this pink string that was strung to where the tree was cut down and secured to a fence. You recall that Mike LaForte figured out what the height was of 39 inches based on the height, the 3-inch placard, and multiplying it by the number of times, and he did all of that. But what he did was he only strung the pink string, so to speak, to show that it was generally consistent with the second volley of shots. And if that's true, that it was consistent with the second volley of shots, this is the back end. You can see from this picture, I want to stand in front. You can see from this picture that what happened is they had cut the tree down and he secured it to the fence, but he went exactly at 39 inches, exactly, and over the middle of the tree stump, and he strung it all the way back to the sign. So why did he use the sign? Because that's where the target was. That's where Corey Jones was when the second 3 shots were fired. So it's not an exact science, but if we generally know where Officer Raja was standing, and that is to the left and up from the 3 shell casings that were ejected, there's a general line to the tree. And so it's likely, even though the police didn't do it, or the FBI, nor did they measure the tree before they cut it down, nor did they ask them to come back out to the scene and do a Leica before they cut it down, even though the FBI knew that the sheriff had done a Leica. But it's likely, isn't it, that what happened was one of the bullets from the second round missed, and one of the bullets from the first round missed, and there's 3 bullets that hit Mr. Jones, unfortunately, and there's one unaccounted for. Who knows where it went? It just was never found. But this whole argument that there's some kind of attempted murder, going on because he's continuing to shoot him and chase him, the shooting was over at this point. Please just remember that. The shooting was over at this point. Ms. Ellis is very eloquent, but she can't create facts. She can't create the facts. And the facts are that there were 2 volleys of 3 shots. There were 6 shots fired. 3 from somewhere around here, and 3 from somewhere around here. And it lines up with that tree, and it lines up with that tree. So now let me sort of see where I am. There's no need to yell drop when somebody points a deadly firearm at you. You have a right to shoot. But he yelled drop both times. And you can hear it. Sometimes you got to strain, and sometimes you got to really hear it clearly. You hear it in the following way. During the first 3 shots, you hear, before the first 3 shots, you hear drop, and then you hear the shots. During the second 3, he yells drop it, and then the shots. So there was an attempt to get him to drop the gun, to get Mr. Jones to drop the gun. Maybe Mr. Jones wasn't going to shoot the gun, or maybe he was, but you can't make that decision when you're out there. Somebody points a gun at you, that's what's going to happen. I mean, think about this. So Officer Raj is not a cop. Just think about this. Just a concerned citizen drives down the off-ramp and sees this car on the side of the road. A concerned citizen. Maybe somebody's having a heart attack in the car. Maybe somebody needs help. They need a lift to the gas station. Maybe somebody's delivering a baby in the car. Who knows what's going on? But a concerned citizen pulls up. Are they holding Officer Raja to a higher standard? Because that's not the law. Would they have charged a concerned citizen who got into a situation where he had to fire his firearm? Or would the concerned citizen be dead? We don't know. But think about the difference and what might have happened out there. So, do we... And as I've said, there's no way to actually know when the fatal wound occurred. But it certainly seems likely, doesn't it, that since Mr. Jones raised his arm twice, had to be facing, sort of facing the person, maybe on an angle, because the shot was front to back and upward. That's another reason it couldn't have been down here. This is a swale. This was an upward trajectory shot. But there's no way to know which volley created the fatal shot. It's likely that it had to be in 1 or 2, and it had to be when his arm was raised. And that's the position, the exact position you're in when you fire a firearm. Now, so these are the lies that the prosecutor says prove the case. And I want to say that the burden is on the prosecutor to prove this case beyond and to the exclusion of every reasonable doubt. And I'm going to talk about reasonable doubt towards the end. But these are the lies that were supposedly said by the officer on his walkthrough. Because that's the only place they could come from. He was standing here when the shots were fired, when the second volley of shots were fired. He was standing here. They're all about whether or not he said certain words. They're all about whether or not his perception was accurate and he was just lying. How do you get that Officer Raja, in that state, lied about anything? He gave a sworn statement. He didn't have to give a sworn statement. He gave a sworn statement detailing what happened. He got most of it right. There's some things he didn't get exactly right. Like, for example, he placed the cones about where he and Corey Jones were when the first shots were fired, right here. Well, we know it couldn't have been there. It couldn't have been on that side of the door. But he generally got this story exactly right. He got right exactly what happened. And those are the lies upon which they build their case. There's no evidence. There's no evidence that he committed a crime here. There's no actual evidence. There's supposition, there's hypothesis, there's Miss Ellis saying, well, he was running or he was doing this. The only evidence we know for sure is that 6 shots were fired, that Corey Jones got out of his car with a gun, that he pointed the gun, and we're going to talk about the laser test in a minute, that he pointed the gun at Officer Raja, and that Officer Raja shot him. As terrible and as sad as that may be, that's the only evidence that there is in this case. And they don't just get to say it. The burden is on the prosecution to prove beyond a reasonable doubt. They've got to bring the evidence. We'll talk to you a little more about that later, but they've got to bring the evidence. What is the evidence that any crime was committed here? Okay, so let's talk for a minute, a little more than a minute, about the laser test. I'd like to run that video. And take this off. You'll recall that the police came to the scene a couple of weeks after this happened, and they wanted to know, why would Officer Raja, okay, just hold it, yeah, hold it for 1 second. Why would Officer Raja say the gun had a laser max? He must have had a reason. You don't make something like that up. Why would he do that? So the police decided to do what they called a light reflectivity test. I don't know if that's a made-up name or whatever, but it was a test to determine what was it that Officer Raja might have possibly seen in that 1 second. Maybe it was 2 seconds max. In that 1 second or 2 seconds, that would make him say on the walkthrough, he had a laser max. I know because it was flashing and it was pointed right at me. A couple of things I want to say about that. It 100% proves that he had a gun pointed at him. Whether it had a laser max or not isn't the issue. But who cares whether it was a laser max or whether it was a reflection off the street light? He had a gun pointed at him, and the sheriff's department proved it. And believe me, if they hadn't done the laser the light reflectivity case, the state would be arguing that he didn't even point a gun at him. But let's talk about, let's show the video. Okay, can we lower the lights? Okay. So I hope you can see that there's a flashing red light around the barrel. In the first part of the video, there's a flashing red light. In the second part of the video, there it goes. See the flashing red light? Now, in the only humorous part of this horrible situation, that guy, Investigator Wills from the state attorney's office, said, well, I couldn't see a red light, but of course I'm colorblind. It's ridiculous, but it's the only thing that's the least bit humorous out of this whole horrible situation. So you've got that pointing at Officer Raja at 3:15 in the morning for probably a second, maybe a second and a half or 2 seconds. One thing is for sure, he had a gun pointed at him. You couldn't make that up. And the second thing is for sure that it was flashing red. Now, we can turn the lights on. This is a still photo. You might recall that Investigator Thomas tried to say they didn't have a video. How come you didn't write in your report that there was an actual video? Well, that wasn't actually a video. I mean, I did it on my camera. Well, Mr. Richardson cross-examined him. Maybe it was a flash video, whatever. We finally got a hold of it. Until then, we had this. But this is a photograph taken that night. It's taken by Investigator Thomas, and it shows Investigator Wills pointing the gun at where they believed Mr. Jones would have been standing in the direction that Mr. Officer Raja would have been standing. So, here's what the state does with that information. They try to argue, well, you don't have the exact spot. You don't know exactly, you estimated. This is the crime scene guy that did the measurements, by the way, Thomas. He knows where the car was, and he knows about where the gun was held. But they try to run away from this. You might recall that it wasn't until they recalled Thomas that all those pictures and the video came into evidence, because of course we were going to put them into evidence if they didn't, and that was very clear that it was going to come out on cross-examination. So dozens of pictures and the video was finally admitted into evidence in this trial. This evidence, likely the most crucial piece of evidence in the whole case, because this evidence establishes beyond any doubt, beyond the shadow of a doubt, beyond all doubt, that Officer Raja was confronted with a handgun pointed at him at 3:15 in the morning. And at that point, everything changed. You can't negotiate with that. You can't negotiate with that. You can be dead in a second. In a second. It takes a trigger pull. And you might recall the ATF guy who now works for the Sheriff's Department, I think his name is Barberini. Barberini said, that gun will kill you. There's no question that that gun will kill you. And how would you know that the safety is on? How would you possibly know that the safety was on that gun? And you know how long it takes to flick a safety? What, 1/10 of a second? Flick the safety to off? Maybe 1/10 of a second? So there's some testimony or some suggestion that maybe Corey Jones is a lefty and he wouldn't have held the gun in his right hand. Okay. Well, the uncontradicted evidence is that he was holding the gun in his right hand. It was a right-handed safety. It was a right-handed gun, which means that the safety is on the left side. You can flick it with your thumb. So is he a righty or is he a lefty? It's hard to tell. But he was holding the gun in his right hand. And you may recall, and it's in evidence, that Mr. Jones's wallet was in his right front pocket. So I'll go out on a limb and I'll make the statement that most righties would keep their wallet on their right side. Maybe not all, but in any event, the gun is pointed at Officer Raja. He has a 1/10 of a second to register and to do something about it. Maybe that gun was up there for a second. How many hours did the state spend in this case proving that it didn't have a laser max on it? How many hours did they take? I mean, witness after witness, I mean, it doesn't look like a laser max to me. Although Wills said Doesn't look like a laser max to me. Of course, I've never seen a laser max. Thomas said, well, it doesn't look like a laser max to me, but I've never had a gun pointed at me in the middle of the night with flashing red to kind of know what it would look like. But does it matter? Does anyone care whether it's a laser max? What matters is that the gun was pointed at Officer Raja at 3:15 in the morning, at about that height, and that's what he was confronted with. So, we know there was a gun. We know that it had a red flashing light attached to it. Even you can't see flashing in the picture, but certainly you saw it in the video. There was, and you can watch that again if you need to. That the gun was pointed at him, and it had to have been pointed directly at him to pick up the red flashing light. And why does it matter whether it was a laser max or some other kind of laser or no laser at all? It's what he perceived in a second. In a second, in a split second, he had to make a decision. He saw the gun and yelled, "Drop." The prosecution has the burden of proof. Let's see what else I can drop here. The prosecution has the burden of proof beyond a reasonable doubt, beyond every reasonable doubt, and we'll talk more about that later, of disproving self-defense. They have the burden of proving beyond a reasonable doubt that Officer Raja was not justified in using self-defense. In other words, they have the burden of proving that he did not have a gun pointed at him. And how are they going to do that? They can't do it because he did have a gun pointed at him. And everyone knows that he had a gun pointed at him. And he couldn't have made that story up. You couldn't make that story up. Why would you say it if it wasn't what you believed? But speaking of the gun, there's a new twist today. I interpreted what Ms. Ellis said to suggest that the gun was planted? That the gun was planted? Does this look like it could have been dropped here at this location? If she's saying that, there is absolutely no evidence. They couldn't even find the gun until the dogs came. They couldn't even find the gun until the dogs came. Even though he was saying, there's a gun. You know, there's a gun. I swear to God there was a gun. They couldn't even find it. And what, again, would be the benefit of planting the gun there? Is she trying to suggest that maybe Corey Jones was chased down into this gully, gunned down, and that Raja came back here and planted the gun and made up a story? Well, I could make up a better story than that. How about go in the van and put the vest on before the police arrive? How about that one? How about putting the gun in Corey Jones's hand? How about that one? But no, he didn't make up the story. He told the truth about what happened. What he said happened was exactly what they determined from the physical evidence did happen. He turned, he pointed the gun at me again, I discharged my firearm 3 times, he fell, something silver fell, and he ran off into the darkness. And no mistake about it, when he was on the 911 call, he was still in fear. He had no idea whether Corey Jones was in the vicinity, whether he was armed with another firearm. You'll remember, you can't assume that it was only one. He had no idea about that.
60 minutes comes.
I have 60. Okay. He had no idea about that. All he knew is that I'm scared. I'm not covered in anything. Remember, he said that on the 911 tape, and you'll listen to it again, I'm sure. I'm not covered in anyone. I shot him. He turned. He pointed the gun at me. I fired. I gave him commands, which is true. He did give him commands. I fired. He turned again. I gave him commands. He fired, and he did. Drop and drop it. He didn't have to give him commands. He didn't have to do that. He was faced with deadly force, and he did not have to give him commands, but he did. The prosecutor would have you think that he was out hunting that night, that he was hunting for somebody to kill, that this man was out there on the prowl hoping that he could kill somebody. And here's the argument that she makes. Here's the argument that she makes. Well, there was a guy walking his dog in the neighborhood, and he showed him his ID. Well, the guy walking his dog in the neighborhood didn't pull out a loaded firearm and point it at his head. He was walking his dog, so he said, "It's okay, I'm a police officer, it's okay," and he showed him. There was no chance for Officer Raja to show him anything. There was no chance for Officer Raja to identify himself other than saying it. This happened the second Corey Jones got out of the car. And why was he so quick to get out of the car? What was that all about? Something clicked inside his head that he had to get his gun and get out of the car before he ever saw Officer Raja. Unfortunately, we'll never know. So, I'm reminded that I have that transcript of him saying drop and drop it. Okay, thank you. All right. So, this transcript, this is the transcript, the first one, of Officer Raja saying the words to him when he was still approaching, before the gun was pulled. And what you can see here is, and this is an agreed-to transcript. They call that a stipulation between the prosecution and the defense. But what it means is both sides agree. So what this one says is, I don't want to block you, but distant talking, UI talking. So unidentified. So what we know is that the sounds of the door chime are ringing and somebody says something. So we tried to determine what it was that was said. That's why Mr. Piazza testified. Okay. We couldn't determine what it was said, but we determined, uncontradicted by anyone in the case, uncontradicted, that it was probably 4 syllables. Probably 4 syllables. Okay, so what would 4 syllables be? I could make something up, but I know that he said that he told the police on the walkthrough video that he identified himself as a police, and we know that Mr. Jones said, "I'm good," after he heard him. He said, "Ha, I'm good." So possibly Officer Raja said, "Police, you good? Police, you okay?" "Yeah, I'm good." Well, from that moment, he pulled the gun. So anyway. Okay. This is an agreed upon in evidence transcript In other words, prosecution agrees and the defense agrees that this was an accurate transfer. So, before the first 3 shots were fired, Officer Raja, NR, Nouman Raja, says drop. And before the second 3 shots were fired, he yells, drop it. Now, I'm going to tell you, if you go back and listen to it, you got to listen. You got to listen, because as we're getting away from the car, Officer Raja's voice starts to fade away again as you're going up the off-ramp. But gunshots are heard after the second drop, after he says drop it, and gunshots are heard after he says drop. So this wasn't like he was hunting. Is that what she said? Is that what counsel said, he was hunting? So let me talk about this testimony of Dr. Joost. In order for this theory of the prosecution to work, and I'll call it a forced theory or a contorted theory, because everyone's upset that this happened. Believe me, everyone is upset. Everybody at defense counsel's table is upset that this happened, and everyone at counsel table for the prosecution is upset. For Dr. Joost, I'm going to be as respectful as I can. She's an outlier. She has no idea of the literature in this case. Is there anybody who thinks that Dr. Joost knows more than Dr. Nelson? No. So Dr. Joost, contrary to all of the literature, contrary to the 2 most famous textbooks on the subject, and this was brought out, Spitz and, this is heavy, so I'm not going to hold it for too long. Spitz and Fisher's Medical Legal Investigation of Death, edited by Warner Spitz, written by Spitz and Fisher, and the most famous of them all, Vincent DeMaio, who has written a book on gunshot wounds. But it's not just that. It's universally taught. These are the textbooks that pathologists use. That's a board question. It can be asked on the board when you're trying to get board certified in pathology about whether or not damage to the heart can stop you from running. It can stop you from running, but not until the oxygen supply to the brain is gone. It's all about the O2 to the brain. And she finally admitted that on cross-examination, but she wanted to say that this is different. This is different. This case is different. This case is exactly the same as hundreds and hundreds and hundreds of other cases. And I hate to talk about it as a case. I know this is a person. This is a human being. And I know that Dr. Joost wants to help. But she's a scientist, and she's supposed to stick to the science. And the science is universally against her. A person can have the heart removed from the body. A person can have the heart shredded, in other words, obliterated, and they will have 10 to 15 seconds of an ability to run. You heard Dr. Nelson. The stories are legion. City blocks. I mean, he gave the example of one that was recently in his office. And it became about a 10 or 15 minute cross-examination segment just about that one in his office. But in that case, somebody was shot, ran down the stairs, ran across to a neighbor and ran up the stairs and was knocking on the door when he finally expired. We don't know how long he was knocking. We don't know how long it was before he ran down the stairs, but it became about that case. There's thousands of cases. The textbooks are very clear on it. I suggest to you that you cannot rely upon her, and the entire state's case is built upon her. If Dr. Joost is incorrect, and they have to prove beyond every reasonable doubt that she is correct, but if she is incorrect, none of this theory that the prosecution has propounded works. None of it works. Because the final shots are fired, 4, 5, and 6 here. He goes down there. He goes down there. He falls and he's dead. There. If Dr. Joost's theory is correct, he has to go down right there. So maybe they're going to suggest, oh no, well, we'll come up with a new theory. We'll come up with a theory that maybe these 3 shots were fired way off into the darkness, where the police with flashlights couldn't even see, and car headlights couldn't even see. And maybe these 3 shots, because they were fired 1, 2, 3, maybe all 3 of these shots hit him, or at least one hit him, in the darkness. Don't know. Maybe that's what the theory is going to be on rebuttal. That somehow he was standing here and he fired into the darkness, but how come he fell and there's the silver handgun is right there? And by the way, think about the timing. These shots were very close together. 1, 2, and 3, and 4, 5, and 6 were very close together. I don't know if we have anything that has the timing on that. Okay. So I think what I'm saying to you about Dr. Joost, you have to reject her testimony, or at least you have to say there's a reasonable doubt in her testimony. And I'm not telling you what you have to do, but that's what the evidence is. Dr. Joost is not telling it like it is. She's an outlier. Dr. Nelson put it a different way, and he said she's certainly not familiar with the literature in the area, or she doesn't understand it. But she did say one thing which I want to mention. She said, I remember I was cross-examining her, and it's petty, but there was a reason I was doing it. I was cross-examining about the fact that she made 3 errors in her report. They weren't substantive, giant errors. But the point I wanted to make then, so that I could talk about it now, people can make mistakes without it being a lie. People can make mistakes without it being a lie. She made mistakes. She was careless. She got the amounts of the blood in the chest cavity wrong. She got whether a wound was a perforating or a penetrating wound wrong. She did that, and it didn't affect her ultimate opinion, obviously. She was locked into that opinion. But what she was saying is, yeah, that's a mistake. I mean, she finally said that, but it was a typo or whatever. All I want to say is that Officer Raja made some mistakes about locations and perception. He had perception distortion. And this is a good time to talk about mistakes. You heard from Dr. Trumpeter. Dr. Trumpeter wasn't brought in a year after this to interview Officer Raja, what good would that do? No, he was brought in to talk about the phenomenon that is known very well to psychologists who work with deadly force incidents. There's only 73 in the country that are board certified in police psychology, I believe he said. And he's one of them, and he's obviously a well-educated man. But what he says happens is you get perception distortion. Here are the classic signs. You get your locations, your positional locations wrong. Your timing is wrong. You get tunnel vision. Remember he talked about it, the example he gave was there could be an elephant standing next to you and you wouldn't see it if there was a gun pointed in your face. That's just psychology. I mean, and I don't know that you need an expert to say that, but I think you'll probably remember that I talked a little bit about memory and voir dire and jury selection and what factors would maybe impact on memory. And pretty sure that everybody that's sitting here said, this group said stress would be one of the factors. But none of us can imagine, unless we've been through it, what having a gun pointed at your head and thinking you're going to die and having to shoot somebody, what psychological impact that it could have in the very hours after it happened. Yet, Officer Raja was pretty darn close to what happened. He was pretty darn close to being able to locate himself, locate Corey Jones. So the only mistake he made, really, from a distortion point of view, was he thought Corey Jones had fallen here and he fell here. It's really not much of a mistake, and it's really not inconsistent with anything, except that now we know, because of the gun, we know exactly where he was. And you know, pretty much that's what he said. Remember, I was talking a few minutes ago about what the lies supposedly were. So I want to just go back to that. The prosecutor says that here's how you know that guilty is a cold-blooded murderer, that he tried to gun down first-degree murder Corey Jones, and that he was reckless and careless, and I'm going to talk about the law in a minute, but that he was reckless and careless. Here's how you know. Because he's a liar. So here are the lies that in the hours after this horrible shooting, he thought, this is classic trumpeter material, he thought, and he told them, that he was on the phone with 911 when the shooting occurred. Now, counsel acknowledges, and she did today, that the police officers know these 911 calls are recorded. That would be about the stupidest lie you could make up if it was a lie. That I was on the 911 call, the gunshots would be heard, it would be clear, it would be happening in real time. Obviously, he was mistaken. He had perception distortion. He had that time thing, the timing of sequence things that these guys get. But obviously he wasn't on the 911 call. And obviously that wasn't a lie. He thought he was. But that's what happens to these guys. He thought he was on the 911 call, or he wouldn't have said it, because it certainly wouldn't help him. He misplaced the cones. So he misplaced the cones. Again, perception distortion. This whole incident lasted seconds. and he had a gun pointed at him, and he didn't exactly get the tones right at this point either. But by the way, the officer told him to estimate or to guess, take a guess as to where you work. When he said, I don't remember, I'm not sure, we'll just estimate. Estimate has now turned into a prosecution lie to convict a man of attempted first-degree murder and manslaughter by culpable negligence. He didn't remember word for word what he said to Corey Jones. So he didn't get, by the way, he didn't even remember, he couldn't even remember hearing the gunshots. Remember he said that? I don't even remember hearing it. And that, I think Trumpeter said that's one of the more common things that happens to these guys. It's classic. They have a hard time seeing, hearing, perceiving. But he didn't get his statements exactly correct. But he got some things correct. He did give him commands. Commands means drop the gun, drop it, drop. He did that, that's for sure. He did say something to Corey Jones as he was exiting his car. What would an officer say other than police? What would they say? What would he be saying? If he didn't say police, you okay, or police, you good, what would he say? What would an officer say upon leaving? This isn't some rogue police officer. This is a real police officer. What would he say? I don't know. He'd say something like police, or he might say, "Are you okay?" I mean, who knows what he would exactly say, but he would likely identify himself as a police officer. And they're saying he didn't identify himself as a police officer because you can't hear it. But we know that the microphone doesn't pick up. I want to point to this a little bit more. We know that the microphone doesn't pick up when he's around this side of the car. And you don't just know that from the original, not the original AT&T call. You know it in another way too. Remember Suzanne Brown? She was the sound person from the FBI lab. You know what? So I don't forget. I want to say something about the FBI lab. Mr. Fernandez cross-examines witnesses. Well, what did you get paid for your testimony here? And how much did you get for this? The implication is that these experts lie for money. But forget that. That's not the point I want to make. But that's the implication. But you know what? The state gets it all for free. They get the best experts in the country for free. They get the FBI, and I brought that out from, I think it was Suzanne Brown, but I brought it out. They get the FBI to give their services for free, all of their expertise. They get alcohol, tobacco, and firearms. They get all of this stuff for free. So we don't get to cross-examine them and say, how much did you get paid? Because I got my salary. Well, I'll tell you what. Mike LaForte gets his salary. That's what he gets, his salary. But is it really fair for the prosecution to say, how much did you get, when they get it all for free? They get the best of the best, all for free. So, I know I said something about this before, but I want to just reinforce it. Officer Raja, he got read his rights on the scene. He had a lawyer there. He didn't have to give a statement. But he gave, I believe it was over an hour statement, subjected himself to the examination by 3 different police officers on the scene. You heard everything he has to say. You've already heard everything he has to say. But he had nothing to hide. There was no reason for him not to give a statement. He didn't know that they were going to take these little mistakes, I'll call them, about what he said and when he said it and where he placed his cone, and turn it into some prosecution for attempting to murder somebody and for manslaughter by culpable negligence. So that brings me to manslaughter and I need the two to This would be interesting. I'll pick up this book. All right. Okay. And then give me a third one, which is the technical person. So every charge, as His Honor will tell you, is broken into parts. Like some have elements. The parts are called elements. Some have 5. Some only have 2 elements. But every charge, you must prove each of the things that relate to the charge, called elements, or the entire charge is not true. So if there's some charge that requires 5 elements and they only prove 4, I'm not saying that happened here, but they only prove 4, that charge would not be proved. But I'm only saying that because I want to highlight what the elements of manslaughter are. And bear with me because I got to read this. Because the state has consistently left this part out when they've read it. Every person has a duty to act reasonably, and you've got this, to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. So, if you have no intention to harm, and unfortunately you're in a terrible car accident, then it can just be negligence and you're not guilty of a crime. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable, as I have previously instructed you. That's a separate issue, justifiable or excusable, that I'm going to talk about. But I want to talk to you about negligence versus culpable negligence. In order to be convicted of manslaughter, you must have committed culpable negligence. So I'm going to read the definition of culpable negligence, but then I'm going to point out the part that always gets left out by the state. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. But here's the part that always gets left out. I haven't even read it yet.
30 minutes, counsel.
30. The negligent act or omission must have been committed with an utter disregard for the safety of others. And here's the line. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. So, as to culpable negligence, the state must prove to you, beyond and to the exclusion of every reasonable doubt, that Mr. Raja consciously did an act and followed a course of conduct that he must have known or should have known was likely to cause death or great bodily injury. Not just that he should have done this or he should have done that. Not just that he was negligent even, but he must have had that requisite intent, that the intent requirement is that he knew or should have known it was likely to cause death or great bodily injury. How could he have known that Corey Jones was going to pull a gun on him? How could he have possibly known? You could even stretch it to say, well, maybe Corey Jones would have been nervous. But you can't just pull a gun on somebody if you're nervous. People get approached by strangers all the time. You can't just pull guns on them. And that's the part that gets left out, and that is the key to this whole thing. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known, not even might have known, must have known, or reasonably should have known that getting out of his van was likely to cause death or great bodily harm. And I say to you, that's not proven. Now, attempted first-degree murder is not proven either. Attempted first-degree murder means you had a premeditated design. You intended to commit first-degree murder. There is no evidence at all of that. There is none, not a little, there's no evidence at all that Nouman Raja intended to commit first-degree murder but was prevented in doing it. I don't want to misstate it. Deadly force. Oh, this is attempted first-degree murder. Okay. A premeditated design to commit first-degree murder, but didn't do it. In other words, was prevented or blocked in it happening. You've got the instruction there. But a defense to both of these charges is the justifiable use of deadly force. Now, let me say this, I'm going to say it twice. The state must prove beyond a reasonable doubt that the use of force by Nouman Raja was not justifiable. Nouman Raja does not need to prove to you, in order to get an acquittal, that it was justifiable. The state must prove beyond every reasonable doubt that it was not justifiable use of deadly force. That burden is important, and you'll recall the judge harped on that burden during the jury selection stage of this thing. So, deadly force is justifiable if Nouman Raja reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself, while resisting another's attempt to murder him or any attempt to commit an aggravated assault. And an aggravated assault means pointing a deadly weapon at somebody is an aggravated assault. Pointing a deadly weapon at somebody is an aggravated assault. So I'm not going to go into reading all of it, but Nouman Raja was justified if you believe that Corey Jones pulled that gun on him and pointed it at him, or even pulled the gun on him and pointed it away from him, would have been enough. But if you believe that he pointed the gun at him, it's justified. the use of force is justified, and the state cannot prove beyond a reasonable doubt that it wasn't justified. Now, they'll argue possibly that he brought this on himself. But Corey Jones didn't go back to his car and get the gun when he saw what was going on. Corey Jones came up with the gun, and he pointed the gun at him within seconds of Nouman Raja approaching him. And if he pointed the gun at him, that's an aggravated assault, whether he was going to pull the trigger or not, and Nouman Raja was entitled to act accordingly. Can you give me a 15-minute warning?
Sure.
Thanks. So, let me talk about reasonable doubt for a little bit of time. No, you know what? Before I do that, I want to talk about that animation. I did say, and it's certainly not in dispute, that animation is not in evidence. Really, all it is a prosecutor's argument. That's what it is. It's not been subject to cross-examination. It's not been pointed out that that they got the facts wrong, that the positions of the shoot of Nouman Raja when he fired the shots is all wrong. It's not, none of that. But I just want to make sure that you understand that the animation is an argument, and it's an incorrect argument at that, because when you compare it to the evidence in the case, it's wrong. But you'll see that. So back to jury selection. Do you remember during jury selection that I harped on, and His Honor harped on in a different way, and I'm going to talk about that, presumption of innocence and proof beyond a reasonable doubt. And I said, and most of you were asked this exact question, I said at the time, isn't that what makes our country different from some of these other countries in the world where you don't have rights? I think I said Iran, and I think I said North Korea, probably. I might have said China, I don't remember. But remember I said that. And I asked a certain question, and I know it got repetitive at the time, but I asked a certain question to bring that point home about how important presumption of innocence and proof beyond a reasonable doubt is to our system of justice. So you'll have a flashback, hopefully not a nightmare, to the question that I was asking each one of you, each and every one of you. What is worse, convicting an innocent man or finding a person who committed a crime not guilty? And I asked that question because I was trying to bring home the value that we have on proof beyond a reasonable doubt and presumption of innocence. Would we rather make a mistake on the side of convicting an innocent man, or would we rather make a mistake on the side of finding a guilty man not guilty? And every single one of you that is on this jury said it would be far worse to convict an innocent person, or it would be worse. I don't want to, you didn't all say far worse. It would be worse to convict an innocent person of a crime he didn't commit, so that we can have our system in place, our system of justice, our system of a presumption of innocence in place, rather than us being in some foreign country. I got so repetitive with the question, I stopped asking the question and I just said, worse or better? And you guys probably remember that. At some point you remembered the question, because you're probably getting a little tired of me saying it, but I had to work my way back through about 6 or 7 rows. And I finally stopped asking the question and I just said, worse or better? And you all answered it. And that meant you were committed. The people that are on this jury were committed 100% to the concept of a presumption of innocence and proof beyond a reasonable doubt as a requirement. His Honor kind of approached it in a different way. he said words to the effect of, you might not hear anything from the defense at all. You might not hear any witnesses at all. But will you still hold the state to its burden of proof? Will you still analyze the state's evidence, the prosecutor's evidence, to make a decision about whether or not it rises to the level of proof beyond every reasonable doubt? That's kind of how he did it. But the goal was the same. He wanted to make sure, I'll speak for him. I mean, I don't know what he's thinking, but I assume I know what he's thinking. I'll speak for him that he was trying to assure that you all believed in our system also, that you would uphold that presumption of innocence and that requirement of proof beyond a reasonable doubt. So cutting through all of that, what does reasonable doubt even mean? Because it's so hard to get your arms around a concept like reasonable doubt. So I say, reasonable doubt means you're sure. You're sure. You have that much confidence in something, in an opinion or whatever, that you're sure. Maybe another word would be I'm positive that it's correct. So those are the kind of words that I would suggest to you come to mind when you're talking about reasonable doubt. Not just, it might have happened, not just what tie am I going to wear to court this morning, not just, hey, where should we go this weekend? None of that. Important decisions, the most important decisions of our lives, are held to a much higher standard. So here's one that I'll throw out at you. It would be like if you had to make a decision, for example, on who the surgeon for your child was going to be, who was going to perform life-saving surgery or not be able to save his or her life. The certainty that you'd have to have in that type of situation, you do your research, you interview the doctors, that would be the kind of surety that I would argue applies to reasonable doubt. Because that
Objection, Your Honor, mischaracterization of the law.
All right, ladies and gentlemen of the jury, this is closing argument. So remember I said that what the lawyers say is not evidence, and they're making argument. And remember, in your hand is the actual instruction, the law, on what reasonable doubt is. Not imaginary force, speculative doubt, not one that wavers and vacillates. I'm doing this off the top of my head. You got it in your hands, okay? Go ahead, Mr. Lubin.
So I would argue that that's the kind of surety that you want to have. You want to be sure in your heart in the most important of matters before you make a decision. And I guarantee this is an important matter. So I don't want to suggest to you that there's a hard and fast definition. But those are the words that come to mind. And the words that don't come to mind, or maybe, possibly, could be, those words don't apply to reasonable doubt. And what would happen if we moved away from that? If we moved away from that high standard that we cherish, if we moved away from presumption of innocence and the requirement of proof beyond every reasonable doubt, I'll tell you what would happen. Innocent people would start to get convicted. That's what would happen. So let me talk to you for a few minutes about reasonable doubts that there's a lot of them in this case, but I'd like to throw a few at you. So Nouman Raja said that the man, he didn't know who it was, pointed a gun at me and that it had a laser max on it. And that was important because that proved that if it did, that proved that the gun was pointed at him. And rather than acknowledging that you couldn't make that stuff up. Who would make up a story about a Laser Max? The state spent witness after witness trying to disprove that it was a Laser Max and that it didn't look like a Laser Max. In that 1 second that Nouman Raja had to look at it, they spent witness after witness trying to prove that it wasn't a Laser Max. Well, I'll say it now. It's not a Laser Max. I mean, I think we're clear on that. It had a red flashing light that he saw, but it wasn't a Laser Max. And that doesn't matter. The fact is that it proved beyond all doubt that the gun was pointed at him, right at him, and that he saw it. Is it a reasonable doubt that the state has created this story without evidence of what happened that night? They've got a whole scenario going on, and there's no evidence to support it. The evidence in the case are the gunshots, the statements made, the forensics, that prove where the things were at the scene. That's the evidence. This other stuff about Corey Jones, and he's running at night, and he's fearing for his life, and he's going like this, and he's shot in the... There is no evidence of any of that. It's hypothesis, it's speculation, and I just want to distinguish that. It's not saying it's not proper argument, but it's not supported by the evidence. So I could go on and I could list all of the reasonable doubts in this case, but you guys know the evidence in this case as well as I do. I could list all of the reasonable doubts in this case and why, whether Mr. Raja made a mistake or not, whether he shouldn't have gotten out of his car at all, or he should have gone to a separate location and changed before he viewed the abandoned car, all of those things. But the fact remains that there's a reasonable doubt, isn't there, about whether he knew or should have known that his actions were likely to cause death or serious bodily injury? Why would he think that assisting a motorist on the side of the road, whether he was on duty, whether he was off duty, whether he was a cop, whether he wasn't a cop, would make a difference that would end up in a life or death confrontation? And to argue attempted premeditated murder, that he was trying to murder Corey Jones, that he was literally out to hunt him down and murder him, when there is nothing in the evidence to support that? There's nothing in the evidence, by the way, to support any of the state's theory. They've got this scenario going on that they want to propose to you, but there's no hard evidence about any of this stuff. Any of this stuff. So I'm not going to talk about lesser offenses because Nouman Raja is not guilty, and he should be found not guilty. And that doesn't mean that this isn't the saddest thing that could ever have possibly happened. It's horrible, but that doesn't make it a crime. It's so horrible, I have a hard time even talking about it when I get up here, but that doesn't make it a crime. The evidence in this case is not proof beyond a reasonable doubt that he committed a crime in any way, shape, or form. And so I'm going to ask you, I'm not even going to talk about those lesser included offenses. I'm going to ask you to return a verdict of not guilty because the evidence is not proof beyond a reasonable doubt. Thank you.
Thank you. Okay, jurors, remember our plan. We're sticking right to it. So we're going to take a 5-minute break again. The official clock says it's, we'll call it 11:56. So 12:01 for the public that's in the courtroom. Everybody be seated by 12:01. 5-minute break. State, get yourself set up, and we'll bring it home. Yes, sir. You got it.